It's working, okay. Good morning, everybody. And first of all, of course, let me thank you for inviting me to chair this session, which is about to address a very stimulating as well as important issue, the one of consent. I believe that our discussion could start from a need that is felt increasingly, that of reconsidering consent both in traditional reality and the new virtual or IT context. And I give you some of my personal idea, not official idea of data protection, European data protection authorities, or data protection Italian authorities. Some of my ideas are personal ideas. Looking at the traditional or offline world, the main issue about consent would seem to be how to provide adequate information so that person consent is really an informed one. Another equally important issue is whether consent should be regarded in all cases as a suitable foundation for processing personal data, even though there is actually no choice available. And finally, still looking at the traditional or offline world, one should wonder whether it is appropriate to ground all data processing operation in consent. Indeed, it might be preferable, at least in some cases, to aim at putting adequate safeguard in place, also in traditional data processing context. But these issues and the question take on increased importance if one considers the virtual reality made up of the Internet and electronic networks. We all know that the development of the Internet and new technologies have been challenging the concept of consent, developed in particular by the European law. This applies especially to the giveness of consent and the possibility to obtain proof of consent. In European experience, in connection with Article 7 of Directive 95/4060, the requirement of consent is very specific. Consent to processing of one's personal data must be unambiguous. That is to say, it must be explicit and specific in connection with the different purposes for which the data are to be processed. At least this is our traditional perspective. This approach is consistent with the view that every data subject must be in control of the data that relate to him or her. Every data subject is master of his or her own data. This approach is consistent with the view that every data subject must be in control of the data that relate to him or her. But how can these requirements remain applicable on the Internet? What does it mean to give one's consent when on the Internet? And how can adequate information be provided with regard to the possible processing operation, so as to ensure that person is really giving informed consent to the use of his or her data for those operations? The relatively simple concept of really given consent based on clear-cut information, which is already difficult to implement in the offline world, is challenged severely by the Internet. Overall context become by necessity more complicated because of the multifarious, simultaneous ways one's personal information can be used on the Internet. In my opinion, in the Internet, the means of consent change completely, because it's not possible to inform all user about the different data used by the providers and about all different aspects of technologies. So I think in an internet system or in the IT world or in the virtual reality is absolutely important to change a point of view. It's more important to give some information about the risk and especially some information about the measure of protection and the modality of the use of data, and to ask the consent about this information as consent about the risk of use of the data, not about the specific system or specific aspect of data used by the controller, because it's completely different. In my idea, is like in other part of our life, when you have the right to live. When you go to the train, you have the right to live, and you have the right to have a good security measure, good, very clear technical aspect of the transport, the ability of the conductor. But for you, the problem is to be sure that the company is controlled, the company use a good system to transport, and only if there are some specific danger or risk, is important to inform you about to use of the platform between one and one other wagon or other aspect of the transport. Not it's possible to be, is necessary to be setting in the plane and other aspect of this. So I think also in the new world, in the virtual reality, is important to pay more attention about to inform about the risk of users and about to check the secure measure used by the provider, about the technical rules, and about the condition of services. And only in this way I understand what meaning privacy by design, what meaning privacy by default. I think privacy by design meaning exactly I, ex data protection authority, have to pay more and more attention about the technologies, about the condition of the new social network, and about all different aspects of new technologies. And when I have to pay a lot of attention about the right of user to be informed, and to give a general consent about the risk of the use of these new technologies. Also because it's not possible to have a real choice. To renounce to use new technologies means to be outside the world. So it's not possible to use the same point of view used in the past about the consent as permission to use my data, having a choice about the use or not the use. This is my point of view, my personal point of view, and I hope our discussion can give us some deeper ideas about also this point of view. Now I give the floor to our moderator, because he is very competent. All of you know his biography, as the biography of our friends, and I am sure that this discussion could be very useful to improve our sensibility and our capacity to defend the real right of our citizens. Please.
Thank you very much, Francesco. An excellent way, I think, to set the scene. When I run training sessions on data protection for junior lawyers at my firm, I always say one thing. I say, data protection, or data privacy if you want, is mainly about one thing. It's mainly about giving people control, or at least a degree of control, giving us as individuals a degree of control over how our information is used by others. So today's panel and today's session is a bit about challenging that statement. And we have a great panel with academics, with regulators, with practitioners, the industry. And what I want to do, and I will obviously invite all of you to participate, is first of all to look at the role of consent. And the role of consent as a mechanism for privacy protection. And assess to what extent we can continue, as we have been doing in the past, to rely on consent, and whether consent is still a viable proposition as a mechanism to protect privacy. Because if not, what are the alternatives, or what is going to fill that space? And I think that's what I would like to explore. So let's get started straight away. And I'm going to ask you, Amit, in Israel, like in Europe, consent is a key aspect of the law. And what I would like to know, and if you can share with us, is why you think that consent plays such a crucial role and is such a cornerstone of the legal regime, and what that actually means in practice.
Thank you, Eduardo. Well, there are several reasons why consent is important, and I would like to touch upon them. And there are differences between what we think about consent and the mechanisms of consent. In Israeli law, under a rather recent amendment several years ago, there was inserted a section inside the privacy law which says that you need informed consent. And it is drafted exactly as it is in the patient's bill of rights. So the legislator and the legal thinking analogs directly between protection of privacy, including informational privacy, and your control over your body when you get medical treatment. This is how it is, as we say, on the books. This is how it is, I guess, when we ask the man on the street, would you like some privacy? And he says yes. And the same experience that we have when going to a doctor, which is of course important to protect our control over our bodies, and for various reasons. I think I will not go into, even though I'm very tempted because of yesterday's discussion, to go over the importance of consent in the constitutional sense, but rather I would like to go on into the mechanical sense, which we face as a data protection authority and as practitioners. Consent is also a technical means for legal stability. You want to know that you are in a safe zone, that you have consent, because if you don't have consent, this may raise liability, tort liability, and others. So lawyers would like consent, and so would companies. And when we look to the mechanisms of consent, we go back to basic contract law most of the time. And when we look at contract law, then we ask, how do people make contracts? And a wide range of the contracts that we are discussing now are actually consumer contracts. And the issue there is that how are consumer contracts created? Of course, we will hear more about this, I guess. We heard some interesting things yesterday, but the issue is, do people always want to have a contract about their privacy? So I would like to talk about it in three layers. The first layer, which we term in our agency the old world, because it's more convenient, is the layer where we go to the old world service providers for a service, and there are privacy clauses, and we see all the problems of having the contractual relationship between provider and customer. These are problems that will not go away. I will tell you the end, because these are problems that recur in consumer relations. We've seen a very brave attempt to regulate this issue in the GLB model privacy notice. I think it's innovative. I think it's important. It has mainly been done not by lawyers, but by social scientists. And they've been asking, what are people's judgment quality? What are their perceptual accuracy? So in order to give consent, we have to understand, and then we have to consent. This is what informed consent means. How do we achieve that goal? So going back to the three types of scenarios, One scenario is the old world, and there we see these types of problems. The other scenario is the online scenario. And this online scenario divides into two parts, I think. One part is the part that we talk about a lot, the information barter, where we give information in order to get services for free. The other part is the part where we're using a network, and this I just only can quote Professor Rufangel's last remark about using the telephone network. I think that some of the networks have gotten such a market power in both markets, suppliers and customers, that they've become essential networks. And when you look at them at essential networks, you should judge them according to the rules for essential networks, according to rules they themselves would like for themselves in areas like copyright and defamation and all types of safe harbors. So in these areas, consent is not relevant. And I will say this, there are some answers. You may guess where I'm coming from, so I'm a regulator. Some answers are in the regulator's responsibility. They should not shy away. There are a lot of challenges in dealing with this issue. I will give just one metaphor. There are a lot of metaphors about this, about which I looked at, is the issue of cigarette smoking warnings. You know, we have a lot of campaigns about smoking, and a person wants to smoke a cigarette, and there are many ways to tell him about the long-term harms of this. None of them talking about the specific notice has been effective, except if I've read correctly, this is social science, not law. Pictures of people dying in Australia has been effective. So this is how graphic we should get. And this is one point. Another point is that in most of the privacy contracts that we look at, actually, they are contracts. People are not out there, as David Vladek correctly said, to do an information exchange. They are there to do something totally different. They are on the way doing an information contract. And that's why their state of mind is not that of doing an information contract. I think the only state of mind of somebody doing an information contract is indeed the people going to celebrity shows and the like Big Brother, I don't know if you have it in your country, and other things where they show things about themselves. There they are aware that exposure is the main issue. I think I will continue.
Thank you. So from people dying in Australia to Big Brother, loads of implications for consent. Lisa, in the US, obviously the regime is slightly different, but I think consent also plays a role. And what I would like you to explain to us as briefly as you can is to what extent that is you see that as a valid role in today's world.
Thank you, Eduardo. Am I on? Okay. No?
Just keep talking.
Okay. Can you hear me?
Yeah.
Yes, okay. Thank you very much. So privacy has traditionally, of course, been defined as the right to control one's own information. And I will point out that Dr. Weston is sitting in the front row, and how intimidating and how wonderful to have you here. You've certainly inspired a whole generation, I think, of privacy professionals. And of course, you articulated this concept so well several decades ago. In the United States, we certainly view this idea of individual empowerment as a critical base to our laws, as evidenced by the Gramm-Leach-Bliley Act, for example, which regulates the privacy of financial institutions, the privacy of data maintained by financial institutions. And the entire privacy rule under GLB, the Gramm-Leach-Bliley Act, is premised on a notice and choice regime. And that's essentially all it does. And when you cut through all of the exceptions in GLB that allow you to use data without seeking consent, in fact, there's really very little left other than the fact that individuals can, in fact, opt out of allowing you to use data to share it with third parties for their own marketing purposes. So really very little other than that left in the choice regime under GLB. HIPAA, likewise, which affects the privacy of health data, also is premised very much on a notice and choice regime, on the ability to make decisions about one's own health information. The question I think that occurs to us is what happens with unregulated industries. And there are, of course, many entities that don't fall within HIPAA or GLB. The fact is there's very little in the way of requirements in the United States to provide a privacy notice and to provide any sort of consent if you're an unregulated business. The reality, however, is that most companies do in fact provide privacy notices. We have, it's really a de facto requirement in the United States that privacy notices be given. The problem with privacy notices, however, is that the enforcement regime is under Section 5 of the FTC Act, which prohibits unfair or deceptive trade practices. And so in order to avoid the possibility of any risk of enforcement under Section 5, the lawyers like me who draft these notices draft them extremely broadly, pack them chock full of statements to make sure they are accurate. And they will be accurate, but they'll be unreadable by anybody who doesn't have an Ivy League law degree. And of course, there'll be many exceptions and few choices given in these notices. Now, that doesn't obviate the value of these notices, but it does make them extremely difficult, onerous, and puts the burden, of course, on the individual consumer. Now, should we be welcoming the demise of the notice and consent regime? I would argue that we should not. I wouldn't be so hasty as to do that. I think there's certainly lots of reasons to stick with consent for certain purposes. For example, where a use of data would be wholly unanticipated by the user and could result in harm, and I'll give you an example. If my data, if I provided my data to a bank to seek a loan, and then subsequently, maybe years later, that data were then provided by the bank to a future employer for consideration in the hiring process, that would be very problematic. And that's absolutely something that I'd want to know about, and I'd want to be able to consent or not to the provision of data to my future employer. One other thing that I just want to add, we've focused in this debate on the value of consent and the notice that goes with it to individuals. I do think there's a huge value for organizations in preparing privacy notices, and I'd be interested in some of your experiences, but in my experience, when I've worked with companies to prepare privacy notices, and I've done hundreds of these, this is a fantastic soul-searching exercise for the company. The company really goes through a deep dive into their data practices, really understands what their data practices are from soup to nuts, and then that's reflected in the privacy notice that's provided to individuals. And the choices that are provided are very carefully considered. So overall, I think the process of drafting a good privacy notice leads to better protection for data, leads to more privacy-sensitive practices on the part of the company, and of course, ultimately, that benefits the individual who entrusts her data to that company. And I'll end there.
Thank you, Lisa. So if I understand it correctly, what you are saying is that transparency via privacy policies is something that should definitely be maintained, and consent should be maintained on a selective basis. So I detect, and you've explained some of the limitations that consent has. Alessandro, we know from your research that you have studied at length the role of consent in this context. So perhaps you can tell us a bit more about, again, very briefly, about the challenges you have encountered and to what extent they are similar to the practical challenges that Lisa has referred to.
Well, indeed, starting from what Lisa was just mentioning in terms of the evolution of legislation in this area, and linking to something we discussed yesterday at the OECD meetings. The notice and consent, if you go back at the original OECD guidelines, were seen as part of a whole, a necessary part, but not by themselves sufficient. And in certain legislation we have seen in more recent years, we started isolating the notice and consent as if by themselves could solve the privacy problem. And here, I believe, is where the challenge lies, because most of my work driven by behavior economics shows that simply informing consumers is not necessarily enough to guarantee that they will make a decision that later they will not stand to regret. And the three layers of problems I usually discuss in this context are asymmetric information. Even if you provide a privacy policy, you are often not really informing the users in terms of what will happen to the data and what the consequences will be. And the second layer of problem is that even if you could provide all that information, you have a bounded rationality. The user doesn't have infinite time to think through all that information. And even if we add unbounded ability to process all this information, we still have all these cognitive and behavioral biases, which have been studied for several years by behavior economists. And two of these biases, which I've been investigating recently, related to the problem of consent, one is a control paradox. I briefly mentioned yesterday at the OECD meetings. I can, if you want, briefly mention that again, what we mean by that. And the other is the long-term impact of information about you, the impact that it has on others. So the control paradox is this finding we had in several experiments. So we find it pretty robust. Is that when you make people, first of all, control is good. In a normative sense. We do want to give people control. In a positive sense, so in terms of how people really react to control, we find that they react with overconfidence. So we created some experiments where we made the people feel, not necessarily feel more or less in control in terms of disseminating information. But in fact, we didn't change the actual objective risk associated with information revelation. In fact, in one experiment, we make subjects feel more in control, but we increase the objective risk associated with what they were about to reveal. And we found that when they were feeling more in control, they were revealing more sensitive information compared to the group of people who were not manipulated to feel that larger illusory control. Vice versa, by making them feel less in control, again in a kind of illusory way, because the objective risk of revelation had not changed, people were revealing the sensitive information. So there was a dichotomy between thinking in terms of what the objective risk will be, and therefore you decide whether to reveal and how much to reveal based on that, and the psychological feeling of, okay, I'm the one controlling this moment, this particular revelation. It seems that we as human beings pay more attention to the latter than the former. And the last comment, the other side I was referring to, is another example of potential bias. We often don't, even when we rationally stop and think about the long-term consequences of information revelation, not always that really affect how we then make decisions, and this can be problematic when it comes to personal information, because we just found out in a series of studies that when we provide our subjects of the experiment information about you, and this information is positive about you, shows something nice that you did, you won a prize. If we present this information as being recent, you won a prize 12 months ago, it really plays a role in making our subjects see you in a better light. If we present it as having happened 5 years ago, it makes no difference compared to a condition where that information had never been provided. So the good information is discounted very heavily. Good information about you 5 years ago doesn't count. But sadly, we did the same with negative information about you, and we found that the same phenomenon doesn't appear. The bad information about you, regardless of whether it's presented as being something bad you did 12 months ago, or 5 years ago, or 10 years ago, constantly affect negatively the judgment people have of you. So we have this dichotomy between how other people will react to information we have revealed now. We tend to believe that simply because everybody has a skeleton on Facebook, 20 years from now nobody will care. Maybe it's not the case.
Thank you. That's very interesting. Well, this concept of positive and negative information and the importance we attach to that tells us a lot about human nature. What I found quite interesting from what you were saying is that feeling in control can actually lead to give us a full sense of security, which I think could be very dangerous. I mean, Peter, in your experience, and I can see that, I mean, we have questioned so far consent, but no one so far is truly undermining consent in an absolute way. Peter, you have a very, I know you, a very realistic view of the world and what is happening. Would you agree with that, that consent in the context of privacy protection has a role to play? Well, what are your views?
Well, the simple answer is yes. There's two kind of personal observations I have, both in preparing for this and actually being at the event. One of them is I'm reminded that 14 years ago, I started my major foray into privacy actually with a conversation with David Flaherty, who's sitting in the back of the room at that time was the Information Privacy Commissioner of the province of British Columbia. And David was quoted in the newspaper making a somewhat negative comment about the consent practices of my organization. I phoned him up and I said, well, first of all, did you say this? And he said, I might have. Secondly, he said, I said, would it be helpful to have a deeper discussion about the way that we thought about consent and the notice we provide? And he said, absolutely. So I jumped on a plane and flew out to visit David and Victoria, and we went over the way that my organization had approached consent, and I think I'm not being too generous, but David said that he was quite impressed with that. So it's just interesting when we think about where we were then, 14 years ago, to yesterday when we had the likes of Mark Rotenberg and this morning Chris Hoofnagel suggesting we've got to think perhaps differently about the role that consent plays in this. And the second observation I have is that with many of these debates, I do kind of worry that we are a bit either myopic, tunnelier, or somewhat vertical about these things. In other words, we need to think more broadly about consent as part of a bigger play. And let me kind of just talk a little bit more about that. I think it's becoming increasingly clear that the current paradigm of notice, choice, consent is just unworkable in today's information flows. We've perhaps unwittingly, in fact, I think definitely unwittingly, created an environment where it has become the consumer's role to police their own network. And that's just really unworkable. It's untenable, I think, for any consumer. No amount of redrafting of privacy notices, no amount of default settings is going to help my mother understand behavioral targeting advertising, and we should just accept that. But I think it's wrong to say that there isn't a role for the consumer. In fact, what I'm really saying is consumer participation is absolutely important. I think the question is at what level? I think Lisa did a great job of articulating the GLB type thing, but essentially what we've done in the US with GLB is killed about 1 billion trees a year to deliver 1 trillion privacy notices that all look essentially the same. That's unworkable.
Thanks, Peter. I mean, that's where I want to get at, actually, because we're all being a bit cautious about dismissing consent. We are. But we can also see the dangerous consequences of saying, no, look, we should really stick with consent because really it gives us control. When perhaps we really need to look at that level of control. I mean, consent is defined by some laws, and certainly European law is defined like as a freely given, specific, uninformed indication of wishes. That's the definition in the law. So, is it really in today's world, and in the context of the collection of information that happens all around us, in the offline world, in the online world, in the mobile world, which is all around us, is consent really free?
Well, if you just simply talk about the U.S. example and just simply talk about the financial services and health, it's not only not free, it's just meaningless. It's a piece of paper that I receive every time I visit the doctor, which really is nothing more than disclosing information that I really have no choice about. And so it is meaningless in that context. But the thing that struck me with the economist debate between Mark Rotenberg and Jim Harper really, I think, illustrates the challenge that we have. We had Mark advocating for more government intervention. We had Jim saying, no, what we really need to do is create more awareness for consumers and they should control it. It just struck me that what's missing in that debate and what's missing in most of the debates, even over the past 2 days, is quite frankly, what's the role of the organization in all of this? And I know it's perhaps subsumed in perhaps the way that we think about regulation, the organization's responsibility, but I think we've got to be pushing a little bit more about what does it mean for an organization to be accountable for their information that they collect, what sorts of risk management practices they have put in place, how transparent they are about their policies and practices. And what I really meant by these vertical discussions about how do we improve consent is the same as we have a vertical discussion about what should the laws be, or what's the role of the regulator, or how do we increase the enforcement capability. And I think I'm arguing that we've got to think not just about those vertical things, but we've got to think about another vertical piece, which is what's the role and accountability of the organization, and how do we think about those three pillars together?
We'll get into the role of the organization, but you mentioned something quite interesting about the transparency duty. And of course, well, if the consent is not free, first of all, then that fails the first element anyway. But let's assume there is an element of freedom or control in our decision-making process. The second most controversial element, as I see it, is the informed element, the transparency. I mean, Francesco, you're a regulator in a jurisdiction where I know from my experience consent plays a very important role in data protection compliance and as a basis, as a legitimate basis for processing people's personal information. When you as a citizen, not as a regulator, as an individual, you consent to the use of your information by websites that you visit, do you feel that you have the right information to give that consent?
Now, in my idea, the problem is that in a relationship between privates, the consent is important. But and normally is the most important aspect of this relationship. But it's a traditional idea. All our private relationships are founded on the consent, also the marriage. I give my consent to have my wife gives the consent for my husband. But in some other aspect, for example, the right to live is a fundamental right exactly or more than the personal data protection. What means the right to live? Is possible to ask the consent about your life? It's possible to say, if you go to the highway, you can lose the life. You have, I need your consent to use highway, having in mind all different dangers about your life, and this is enough. It's not necessary to have majority secures of protection, rules about the car, rules about the drivers, rules about the highway system organization. So, in my idea, is exactly about the fundamental right of data protection, personal data protection. It's not enough to ask only the consent. If you are, if you give me your consent, is enough for all different aspects of the use of this data. And the new ICT world is more and more important, because it is not possible to inform about all different dangers, all different aspects. And first of all, it's necessary to give rules, more rules to internet system, exactly about the real life. And to ask the consent sometime, to give information enough about the danger of the use of this social network and other aspects. For example, in Italy, Our criminal judge damned Google using not not acceptable interpretation of the right. So I am sure that in the next degree of the judges, the Google will be solved. But one point was very important. Google is responsible because it didn't give information enough about the risk of YouTube used by the citizen. And the citizen use the YouTube in a criminal way, but also because haven't information enough by the provider. So for me it's very important. It's not enough to discuss about the consent. It's more important to discuss about information on one end and about the rule of data protection authorities on the other end. The rule of data protection authority is changing. We have to pay more attention about security measures, about technologies, about information, about the condition of services, about the protection of data, and all different new aspects. We are not only lawyers. It's not useful to have more and more lawyers about data protection. It's absolutely necessary to have very competent authorities able to protect really, in any case, in any situation, our citizens.
Thank you. So, I see from what you are saying now, I can see that there are other aspects of data protection and data privacy that are gaining importance over and above consent. I mean, is that the right way to go?
Thank you for the question. Just to say that we usually, because the way we take decisions and make consent, connect between informed and consent. And indeed, from the regulator's point of view, exactly as Lisa said, there is internal value in going through the information process, and giving notice is important even in context where we already know in the old world that consent is irrelevant, consumer protection and employers in the workplace. We know our employment jurisprudence in Israel, similar to the rest of the world, uses another tool from the toolbox, proportionality, to fashion the relationship, so we should remember that. I think that one thing I want to mention is why is consent and informed consent so attractive? When we think about control, and this is what we want at the end of the day, there is a lot of attractiveness about informed consent because it is the minimal intervention from the point of view of the regulator in the market. We are fixing the market very easily. We are only fixing the information problem. Or so it seems. This is, of course, an illusion, very well depicted in a recent Chicago School piece by Professor Omri Ben Shachar. The good news is, going through that article, that some of those insights which are relevant for any regulatory field have been developed and discussed in data protection. So we have other tools. And at the end of the day, we should give consent its place. I don't think it's not relevant. But similar to the cigarette case example, it should be one of the issues that we look at, and the other issues should be discussed on a technological level. Casey Chappell talked about a uniform privacy experience, and to take Mr. Pizzetti's example, we all put seatbelts when we go in the car. This is something we do. And this is something we should have in privacy as well. And it's also a sociological issue, and I'm not saying anything new about the need to raise awareness. And, but also I think that the informed consent should be more closely regulated in the sense that it should be uniform, because consumers have limited attention spans. Even when they go to the regular doctor to talk about their health, I'm not sure how much they remember at the end. This has been mapped. When they go to take a mortgage, which is an important decision under the GLB, for instance, the privacy aspects are not the main issue, but sometimes not even the mortgage aspects are the main issue because it's a consumer. What I'm interested to hear, if I may, from my American colleagues, is one of the aims of this GLB disclosure was that consumers can choose between providers according to privacy notices. Okay, I get the answer. So
well, let me expand that question, and I think I would like your views on that. But from an individual's point of view, not as a lawyer, as an individual, if you are telling me that relying on consent is a mechanism for less intervention by the regulators, so that because not that level of intervention is not really required, considering, as we are saying, the lack of information in the context of informed consent, that's very worrying. I mean, let me give you an example, which is close to my heart, because again, it's a European example. There is a new data protection directive dealing with electronic communications in Europe, which is in the process of being implemented. And that directive has a provision that says that placing information or accessing information that is stored in the terminal equipment of a user, so in clear English, if an organization or a website is accessing information that is stored perhaps through a cookie or some other kind of device in the terminal equipment, the laptop, the computer of the user, the law says that that can only take place on condition that that individual, that user, has given his or her consent, having been provided with the right information. So, in the context of the internet, and the way and we heard a lot about the technology yesterday, but just in very superficial terms, the way the internet works today, where we just we jump from website to website in milliseconds, and as we download the page, we are served with several, sometimes dozens of cookies, which are basically information that are stored on our computers. How on earth are we ever going to be in a position where we can first be informed about all possible uses of that information, then think about it, and then decide whether we are happy with that or not in the real world, in the way we use the internet today? Because that's in the law. Could that ever be informed consent?
The fact is, we're never going to be able to consent to data uses anymore. Data is ubiquitous. It's like the air we breathe. It's everywhere. It's multiplying. It's molecules everywhere. Oh, is it on? Can you hear me? Okay. Data is ubiquitous, so the idea of actually consenting to each data use in a world where business supply chains are like constellations is just laughable, really, in this interconnected world. So we have to think about other ways of protecting the data, and having practiced environmental law for many years, I go back to my environmental roots and thinking about analogies. So I think about data as air, and I think that we as individuals can't control whether or not we breathe in toxins. We could, I suppose, all wear masks, so we could have those individual protections and seek to protect ourselves, but the better protections really come on the front side, where organizations are helping to keep you safe by not emitting these toxins in the first place. So I think the shift really, there needs to be a shift of emphasis toward the organization rather than the individual, as we've been focusing for the past several decades.
Let me split this down a little bit to kind of maybe think about a solution to this. Well, first of all, let me kind of build on your problem, and I think it was one of a flaw in one of Jim Harper's arguments in The Economist. And his argument was that consumers have lots of an ability to control cookies through various browser controls. That is actually a very true statement. But it assumes that a consumer understands all of the various uses of information and value that cookies might provide or detract from. And I think that's the problem that we're really trying to get to. Or if we think of another example, informed consent for all uses of personal data. Well, I think it's reasonable that a consumer would understand that a bank does not actually produce the statement that they get. That is provided by an outsourced vendor. But should it really be a requirement that the consumer provide informed consent for the use of that third-party service provider? So perhaps a way to think about these is a little differently, and this gets at this notion of what might be an appropriate level of consumer participation. If we keep this back to our bank example, absolutely a consumer should have access to information that might talk about how the bank uses third-party providers. But that's different than consent. Whereas if you can think of an example where my sensitive information is going to be shared with a third party, that seems to me a very appropriate point at where consent should be obtained. So I think one solution we've got to perhaps pursue is the difference between consent and this notion of informed consent for all uses of information. On the former, the information type of thing, it's the bank's accountability and responsibility to ensure that information is both assessed from a risk before it provides it to that third-party vendor, and it's the bank's responsibility to ensure that the third-party vendor lives up to its obligations. It's not the consumer's. I think there's a fundamental difference there of how we might think about splitting it. We absolutely want the consumer to participate. We want the consumer to participate in areas where they have some meaningful control and meaningful opportunity for informed consent.
May I continue on what Lisa and Peter were mentioning? It is quite well known in the behavioral decision research literature that there are, broadly speaking, two types of decisional making problems, so problems with decision making. Some indeed stem from lack of information. But then there is this other category of problems which stem from lack of self-insight and self-control. Self-insight means you are not good in predicting, knowing yourself and predicting how you will react to certain situations. Self-control, you are not that good at resisting certain temptations. For this type of problems, there is no amount of user education, user awareness programs which is going to help. Amit was mentioning the case of cigarettes and labels on cigarettes with scary images supposed to change behavior. They don't work. An even more compelling example comes from studies on certain drugs which have to be used regularly, because if they are not used regularly, not only they don't help, they can actually be in the long run deadly. And studies have shown that a significant portion of patients who are supposed to use these drugs don't use them regularly. They forget, or they don't want even the little cost of going to a certain location, taking the pill, taking a glass of water. It's an immediate cost. It's really small compared to the later danger, but it's immediate. And so they don't do it. You know what works instead? And I'm about to say something which I'm not happy to report, but it tells you something about human behavior. Lotteries. So the same researchers who have shown this problem have shown that if you create a lottery in which every time the patient does take the pill regularly, participate in a lottery of $10. That, crazily enough, is more powerful in increasing compliance in taking the drug than the risk of death maybe 6 years later. So this is the problems we are facing, and I believe that in privacy we are in the realm of problems of self-insight and self-control. Not because the risk is death, almost never is. There have been tragic cases in the past of stalking related to ID theft, but that's really the extreme of the spectrum. But because, using a metaphor from Alvarian, privacy is like a blank check. You write a signature, and you don't know whether this check will come back to you with no cost whatsoever or a gigantic cost. Because we don't know it, and because the cost only arrive later on, we do have to deal with these self-insight and self-control issues.
I mean, from what you are saying, we all seem to agree that if we were in charge of public policy in this area, let's say we made the decisions in terms of what the policy and the legislation is going to be, what we're saying is Well, we do need to start moving away from consent. We need to put the emphasis on notice, subject to the limitations you are talking about, access, you are referring to, and accountability in general, and also echoing Peter's point, taking responsibility away from the individual. So, in this sort of scenario, what's the regulator's approach, Amit and Francesco? Is this scenario that we are painting the future? And if so, can effective regulation take place in that scenario?
Okay. It's a good question, but it's completely different inside our countries or in the wild world. Because inside our country, in real society, it's possible to pay attention to a lot of new, very important aspects, as data banks, as control about the users of data bank, the relationship with the different data bank, the right to access between other providers, other public administration, and more and more. And the Italian authority dedicate a lot of time, a lot of resources to this new aspect of our activity, not only about the right of access, the right of consensus, consent, but specifically about the real security measure used by the biggest organization, public and private, of our country, about data bank, about the security measure used in this data bank, and we have good results because it's a very useful activity for our people. We have a lot of technicians inside our authority. We have a lot of enforcement policies, police prepared to guarantee a good enforcement about the respect of a right. In my idea, our authority are not lawyers. We have the judges for this. We are completely different activity to do. We have to guarantee before to prevent the dangers about the use of data. And also it's possible to pay some attention to lawyers' aspect as a right to access. But only to guarantee the right to access is not useful to have data protection authorities. On the contrary, the judges can pay attention only to real case, personal case. So I am a professor of constitutional law, so I have a clear idea about the duty of public authorities and the differences between data protection authorities and judges, and data protection authorities and lawyers. But it's completely different, the situation about new technologies, because new technologies are typical aspect of globalization, are linked to wild world. It's not possible to manage this problem as national data authorities. And it's not possible to manage this problem as European data protection authority. And I have to use, or I like to use this occasion to give my message. It's absolutely necessary to pay a lot of attention to arrive at international agreements about rules, data protection, personal data protection rules, and more generally about new technologies. And this is the time, because now United States, European Union have the power to guarantee a good rules, but tomorrow no. It is important to pay a lot of attention about the BlackBerry case. Some months ago, BlackBerry have to give the codes to China, to Arabic Republic, and to India. And when China forbid to YouTube or Google to give some services to Chinese people, it's not possible for the international community to guarantee the right, human right of these Chinese people or other people around. So it's absolutely important to pay a lot of attention, to use the time, to have international rule, good international rule, international authority able to effectively using international enforcement power, this is a new reality. Because we have to wait, if you don't use at the time now, it's impossible in the future. Finally, I think frequently is the same situation about pirates some centuries ago. From 2 centuries, England, Spain, and France use pirates one against the other. At the end, they understood that the pirates were against all of different states and a good danger for international commerce crossing Atlantic Ocean and Pacific Ocean, and decided to have international right about the sea. This is the same time now. Thank you.
Yeah, I mean, hearing what you are saying, the reference to the data from the point of view of requiring greater accountability, greater access, etc., taking away the consent element, we are obviously taking away decision-making power, effectively freedom. And what I wonder is whether could this lead to some kind of nanny-state type approach? Peter?
No, I think we've got to be really careful about the language here. At least from my perspective, I'm not at all advocating that we get away with consent. What I'm really saying is that the model that we have created unwittingly is a over-dependence on consent, which has forced the consumer to be policing of their own network. And then we counter that with what's the role of the regulator. What I'm saying is we thought about this in terms of a leveling of the water. We need to lessen the responsibility on the consumer a bit and shift some of that accountability and responsibility to the organizations. So it's the same model, just a little bit more evened out, or more players in the game maybe is a better way to think of it. Instead of just the consumer and the regulator, I think there's an increasing responsibility for organizations.
Your slip of the tongue was interesting. You said we get away with consent as opposed to from. No, it was interesting actually to me.
I was speaking Canadian.
It was excellent Canadian. I think what Peter's advocating, and probably what everybody in this panel is advocating for, is really a hybrid approach. It seems to me that there's a huge need for consent for certain uses of data, and I don't think anybody is suggesting getting away from the need to seek individual decision-making for those types of uses. Now, what those types of uses are, I think is going to be the hardest thing. You know, the devil is always in the details. It's great to discuss theory, but it's much harder to pin that down. But I think there are certain uses about which we can all agree that certainly would warrant consent from the individual. There also seems to me at least to be sort of the other side to this, which is the organizational obligation to make sure data is kept, is not used in an untoward way, in a way that would shock the conscience and would harm the individual. So there is the organizational obligation to act as well, and maybe what that means is that there's more regulation that says thou shalt not use data in these ways without consent, and then thou shalt put in place a procedure within the organization to ensure maybe privacy by design or accountability or some of these other concepts we've been discussing in the privacy community, to ensure that data is not used in untoward ways.
Thank you, Lisa. So so if we're looking now at the future, and until now we have had a very sort of high-level, nearly philosophical discussion. Let's just get a little bit more pragmatic. If we think for a second that this sort of mix or hybrid approach, as you refer to, is where we're going to, and if we believe that that's the direction in which regulation is going and the regulator's role is going to operate, then how can we prepare for it? How can we comply, being really, really practical? How can we get it right in this context? What should be our emphasis? There are people here who represent organizations that are collecting information, and I'm sure and I hope you find this debate interesting, but ultimately, before we go for lunch, what we also want to hear is some practical answers. So what do I need to focus on from now on, in terms of ensuring compliance with this new regime that is coming? What are your views?
Well, I think that our basics are called fair information practice principles. I hope I got it right. And I think that fairness is the basic element that every business should take into account, and the ability for a data subject to understand more or less what type of information is held about him is basic. I think that the failure of notice and choice brings again the need to re-regulate this area with new principles that add to the basic framework, because the basic framework was there because bilateral relationships between a data subject and a data controller were not strong enough. And the other comment I would like to make on a practical level is that I think that there is a lot of role for educating data controllers, because not everybody is Microsoft. There are a lot of small data controllers out there who would have a lot of problems understanding what type of information they collect. I would guess that definitely that happens when they open a Facebook page and they facilitate other types of data collections. They are the bad guys in the data subject, data controller equation, but they actually have no idea what they're doing. So this is a big challenge for regulators. Our Spanish colleagues have done last year shown a system to enable businesses, which is called the value, to enable businesses to check themselves. And I think that we should focus on small businesses because they are also something we should regulate more closely. Thank you.
Two comments. You were suggesting looking at the future. I'll suggest first looking at the past. 30 years ago, the OECD privacy guidelines were already remarkably good. And going back to something I mentioned at the start of our session, it seems to me that one of the problems is that in these 30 years, at least in some regimes and in some countries, we came to equate the guidelines only to consent, notice and consent, and we forgot all the rest of the guidelines that supported the notice and consent. Looking at the future, as you also suggested, I do believe in strongly, as I mentioned yesterday, the OECD meetings, in technology. We have amazing privacy-enhancing technologies which can allow data sharing at the same time as data protection. We face what I believe is a market failure in that these technologies could increase welfare, definitely for individuals, for society as a whole, and still allow companies to do many of the things that they're doing today, but we don't have them as widely available. So this is, to me, where we can have an important contribution by regulation, smart regulation, technologically neutral regulation, which tries to create the incentives for increased availability of those technologies. Kenneth Loudon, a professor at NYU, already in 1996 used this term, co-regulation, co-regulatory approach, precisely discussing a framework where it's not only regulation, it's not only marketplace, it's a combination of technology, marketplace, regulation, trying to nudge market towards the adoption of these technologies, which again can be welfare enhancing and welfare increasing for everybody.
Combining both the past and the future, because I think Alexander was an interesting way of thinking about it. The current legal framework in many ways has helped organizations offload their risk onto the backs of the consumers. And if you take security, for example, which is often in Alexandra's words, an unused thing. We focused a lot on notice and consent, but we really haven't focused on security. So as long as in the U.S. that I match some of the generally accepted practices to say that I'm going to put in place reasonable means to secure information commensurate with the sensitivities, well, that's fine. Once again, we've furthered the responsibility for the consumer to figure out what that is and to perhaps police it. But if we fast forward to the future and we think about businesses and enterprises moving more towards cloud and service providers, I think it's going to be pretty important that we're much more transparent and accountable about what does it mean to have secure practices. What exactly have you put in place in terms of policies, practices, procedures? And that's a very different a way to think about that one simple line that's in a current consent notice, which meets the consent and notice requirements of the existing laws, but in effect it does nothing to provide assurance.
Thank you. So, on the basis of what we have heard so far, for how much longer do you think we're going to see consent having this preeminent role in legislation? Is that going to continue, or is the future we have painted here, which is a future it's not that original, to be honest. It's based on principles that were enacted quite some time ago. But in the meantime, do you see consent over the next few years playing a very similar role to what its role has been until now, or is the future here now?
But depend on about the idea of consent and what is the use of this idea in different aspects of data protection. Because if you think only about the market and the data used for give one specific service, it's possible to continue to consider the consent as cornerstone of data protection. But now we have in front one other reality. I use my provider as a service, but is also a tools for other aspects of my human life and the relationship about my human life. More or less as exactly about the transport. I buy the ticket to go by plane from Europe to United States. It's the company giving me the service to use the plane, but it's possible to have a lot of other aspects of these services. And of course, the condition of our relationship as consumers and company, they have to be clear. But not all different information about the plane, about the pilot, about the stewards, and more different components of these services using my data, for example. More or less, it's the same about the internet system. I have a contract with my provider, but my data go around using provider services for a lot of different reasons, and the provider use this data using a lot of different technicalities. So the condition of the contracts are clear. The consent about this condition could be clear, but about all other aspects. And this is the reason, because I think data protection authorities have to pay more and more attention to this different aspect, and first of all about the right information of consumers about the dangers, not about the condition of the use of data, but about the dangers. And the public authority have to protect the consumers from the dangers using this data for give them the service, not only about the service.
So is your question more about what the future looks like? Or the crystal ball?
Well, yeah, please.
So, I'm kind of both optimistic and a bit skeptical at the same time. Maybe that's bipolar Canadian. The optimistic part of me looks like this in two ways. One, the fact that we're having this debate, the fact that people like Chris and Mark are raising the question about the efficacy of the consent, notice, and choice model, I think is extremely helpful. What it means is that we're discussing this issue when perhaps even as recently as a year ago we wouldn't be discussing this issue. So I think that's just huge, huge progress. I think the other very significant piece of work that has gone on for the last 2 years and is about to go in its third year is this accountability work. And I think Jennifer Stoddard summed it up best. She said, it's a cornerstone principle of the Canadian Act, but her office in particular has done really no thinking about what it means to be accountable. So I think this work around what does accountability mean is super important. So that's very, very positive. On the skeptical side of it is that we are going to continue to perpetuate this consent model unless laws change, because that's the way they're written right now. So organizations like mine need to comply with the law. We're going to need to do our best to write 29-page privacy notices that meet this legal standard of notice, choice, and consent. And that's almost an irrelevant discussion about whether it serves any useful purpose or provides any meaningful protection to the consumer. So we do need to have some changes. On the positive side, I think those changes are perhaps more possible today than they were a year ago, but they're going to take some time.
I think this is just a terribly knotty problem in thinking about this panel today. I actually spoke with a number of folks who are in this room, and while there's a lot of great theory out there, when it comes to hard and fast, concrete proposals about how to write a new law, because I totally agree that it's going to take new legal requirements, I think there's a lot of waffling, a lot of ambiguity around that point. So I love the fact that we're thinking about it, and I think it's folks who are in this room who can take the theory, the philosophy, and turn this into practice.
When I think about a future, if I didn't know that privacy-enhancing technologies existed, I become very concerned and scared and gloomy and pessimistic, because I see the confluence of two trends on the corporation side, an obvious competitive pressure to use personal data in always more interesting ways. On the consumer side, a form of habituation effect in that we become more and more adjusted with more and more revelation, and the long-term impact of this is, at the end of the day, a significant, huge switch in the balance of power. Because at the end of the day, information is power. And the most important economic aspect of privacy is that by giving away personal data, we are giving away power. And we don't know how this power then will be used upon us. And then, when I think that, thank God, we do have privacy-enhancing technologies, then I become less gloomy, less pessimistic, and actually I'm awful. But once again, we do have to solve the problem of making the technologies which have been developed more available and more used in the marketplace.
I think that consent will always remain there as the default, as it is today. And it is the default principle where there are no other more prescriptive principles, I would say. I think that there is some thinking to be doing about the wider applicability of the proportionality principle as a decision-making rational tool. Sometimes it's so obvious, but it's obvious to privacy practitioners maybe and not to other people. Is there a need for the information? What is the need? Can we do it in a less privacy enhancing way? And I think that there will be a need for some sort of stronger regulatory tools here to cover this area, obviously by legislation, because this is intervention in the way people do business.
Thank you. Well, I think we have heard some serious thinking here this morning. We've looked at to what extent the model that we rely on today of notice and consent, to what extent that's unworkable, how other aspects are gaining importance, and how we are evolving towards this hybrid model, although we don't know when we're going to get there and when we're going to get it right. But it's interesting to see that we still come back to some of the original principles to enable our information to be protected. So we're going to finish this session now, but the debate is going to continue. I would like to give a couple of thoughts with you so that you can discuss this over lunch over the next couple of days. One is this. If consent is still going to play a role, and I think from what we've heard today, it's not that we're going to get rid of it, and it's always going to be there. How do we ensure that consent does not become diluted? So even if it has a marginal role, how do we ensure that that role is still a valid one? So that's one thing for all of us to think about. And then we heard it here today, accountability being perhaps this sort of other way of looking at privacy protection. And the question, again, for you to think about, for us, for all of us to think about, is will accountability take the place, going back to what I was saying earlier, will accountability take the space that consent has had? Is that doable? Is that good? On that note, happy thinking, and above all, thank you very much to all of you for your excellent participation.